Welcome to today's conference call from Eric M. Pelton and Associates. I'm Eric Pelton, joined today by Mark Donahue, and we're going to be talking about choosing a trademark. We are attorneys in Falls Church, Virginia, that primarily work with small businesses on all aspects of trademark law, from choosing new trademarks to protecting trademarks to trademark disputes and trademark licensing and internet and social media and domain name issues and any other type of trademark issue that comes up. This teleconference series, this is our third installment, and we hope you'll continue to enjoy it and provide us with some feedback. Today, choosing a trademark, we're going to talk about three main areas here, really. One is the legal framework and background about different types of names and trademarks and which are good ones and which are not as good ones. And then second, some tips and considerations. Tips and considerations for actually going through the process of coming up with names and putting together a plan for a new trademark. And then finally, some practical considerations that take into account both the legal aspects and the real-world aspects of launching a new trademark. So Mark is going to begin with our first section.
Okay, so this is Mark Donahue, and so the first issue is the legal sort of framework that trademarks operate in, the principles that make some trademarks better than others. And the general idea here is the more distinctive and unique your trademark is, the easier it will be to register and acquire rights in, and the easier it will be to enforce against other competitors who are infringing on your rights. The legal principle behind this is the idea that a trademark is supposed to uniquely identify an individual source of goods and services, but a trademark cannot take away from competitors descriptive terms or generic terms that competitors also need to describe attributes of their products to consumers. So, for example, there's a relatively well-known energy drink out there called 5 Hour Energy. This is a rather descriptive name for the mark, or for the energy drink, because they advertise that it gives you energy for 5 hours. They have registered 5 Hour Energy as a mark, but the scope of protection that they have against others is very narrow. So, for example, they tried to enforce it against a competitor who had an energy drink and used the slogan underneath it, 6 Hour Power. But the court said, well, 5 Hour Energy is descriptive, it describes what the thing does, and 6 Hour Power describes what the competitor's product does. And so the court didn't let them enforce those rights against the competitor. Had they had a more distinctive mark, they would have had broader rights. It would have been easier to register, and it would have been easier to keep the market free of other marks that are close or confusingly similar to their own. So as a general rule, when you're selecting a mark, you want to avoid terms that are generic, as in like terms that are actual names of actual products. You wouldn't want to call your cars brand cars, for example. You don't want to use descriptive terms that describe specific features about your product or things your product does. You generally want to avoid geographic terms that talk about where your mark is from. And also there's difficulty with using surnames, whether it's your own or somebody else's. It's harder to get those registered, and the scope of protection sometimes for those is harder to enforce because other people have a right to use their own name. So the best names, the best trademarks, generally fall in this category of marks that we call suggestive or arbitrary. Suggestive names are generally considered the best, and they're not descriptive, but they convey, perhaps in a clever way or some unique way, some positive qualities about your product. but they don't do it so directly and immediately that the competitors need to use those terms also to describe their products. So good examples of suggestive names that we like a lot are, for example, the Nissan Leaf for an electric car. Leaf has environmentally friendly, ideas, around the word. It's light. It's environmentally friendly. It's a great sort of concept to brand an environmentally friendly vehicle with, but it doesn't directly say, electric car or environmentally friendly car, terms competitors would need. E-Beanstalk for online retail store services for developmental toys and games and puzzles. Beanstalk, a childhood, refers back to a childhood story, and it gives ideas about growing fast, and that's also a great idea. Rock and roll for baby strollers. Double entendre with the roll. These are creative, suggestive marks. Other marks that are also strong are arbitrary marks. They're marks that perhaps don't convey so much about a message of the product, but they are coined terms, created just to be brands, and they have very strong scopes of protection against others. Examples of those would be, say, Starbucks or Verizon. Good luck getting Verizon as a trademark for some other type of product aside from phones. Verizon sneakers probably wouldn't work because it's an invented term, and all it means to anyone is the company that sells telecommunications products. That's not true of all words. If it's not an invented word, sometimes you have competitors who use the same word for very different products, and they're allowed to coexist. So Delta Faucets, for example, versus Delta Airlines. Their products and services are so far apart that it doesn't cause any sort of confusion. But if they were both using an invented word, they might be able to gain an even broader scope of protection that would make it harder for people to coexist with them using their mark. And so those are the general principles. You basically want to be creative. You want to make your mark something that's easy to remember, conveys positive qualities about your product, but doesn't do so in such a direct way that it loses its distinctive quality that points directly to you. And so those are kind of the legal principles in a nutshell that you're trying to select your mark within.
Great, and now we're going to discuss how to actually go about coming up with some of these types of names for a new product or new service that you might be launching, or a new company or new brand. I just want to follow up on one thing Mark mentioned. He really talked about two types of names that are good and generally strong trademarks, which are suggestive names and arbitrary or made-up terms. The reason we like suggestive names is that they work well both legally and from a branding or marketing perspective. From a strictly legal perspective, an arbitrary or a made-up word is going to be even stronger than a suggestive word. However, unless you have the kind of resources that a Verizon or a Google has at their disposal to market and make that name well known and ubiquitous, unless you have those resources, having a suggestive name is an easier way to grab a hold of some attention and to grab your customers' attention and communicate to your customers what it is you're doing. Now, if you said to somebody, hey, have you used Google today, they know what you're talking about. But 5 years ago or 7, 8 years ago, if you asked somebody if they had visited Google today, they might think you were talking a foreign language. They might not know that you were talking about a search engine. So that's why we like suggestive names that have both legal protection, creativity, and branding and marketing usefulness. So how do we come up with these great names? We work with clients all the time, mostly after they've come up with names, sometimes while they're during the process of coming up with names, and then we've actually been fortunate to have developed a few products and services of our own that have allowed us to go through this experience. So for example, we came up with an iPhone app. I'm going to talk about the name for that in a little while. So we've actually been through this process ourselves and helped clients go through it on their own. Be creative. The best kind of names are creative. They're things that at first pass sound funny, sound strange, not even sure what it sounds like. I'll give you some examples of words today that are ubiquitous and everybody knows what they are, but when they first came out, somebody would be like, yeah, why would you want to name it that? Who knows what that is? Google, I mentioned that. ESPN, Kodak, eBay. Be creative, you got to think outside the box. Brainstorm, come up with long lists of possible names, possible syllables, possible keywords. I like to come up with sort of variety of syllables or words and then look at combining them in unique ways so that you could take two words that maybe alone aren't that unique or that creative, but if you come up with them and you combine them in some unique way or you bridge them together with some other word or some other syllable to make up a new word, that's really creative. So it's really helpful to brainstorm, come up with huge lists. Don't just hone in on one word. Don't just say, I got to find the one thing, I got to find one thing. Say, no, my objective is to come up with a whole page full of names, then narrow it down to maybe 10 or a dozen, then look at those carefully, maybe put them into some search engines, do some quick searching at the USPTO, and see if any of those are viable to go to the next step, which would even be talking to a lawyer, doing a more comprehensive, thorough search. Another tip on coming up with these names is to do it early. If you're planning a new program, a new service, a new product, don't wait until a week or a month before you have to create the website or order the labels or order the business cards. These things take time to do a clearance search, to come up with a good name, ideally to file a trademark application in advance, let the review process at the trademark office start and give you a leg up on knowing that this is going to be a safe investment in the name. You can file at the Patent and Trademark Office what's called an intent to use application. As long as you have a real legitimate plan to use a name, you don't need to be making any sales at the time you file. Ideally, you want to file 6 months or even a year before the product or service even launches. That way, you have time to clear it, you have time to plan it, you have time to file with the Patent and Trademark Office. Hopefully it goes through their review process, it gets approved, and then gets published in the public record when any outside companies could object if they have any objections, and hopefully clears that process. If you've cleared that process, you're now much, much safer to invest that money and that time in labels, in web pages, in communicating the name to the public and starting to build up a reputation, get publicity, create a Facebook page, all of those great things that now come with the launch of your new trademark. So be early, very key advice. If possible, understood, sometimes it's not possible. You come up with something great, you want to be the first to market, you got to do it. Still take the other steps in terms of being creative, brainstorming, and at least starting a comprehensive search and a filing process so you do what you can with the time you have. Another thing to consider practically in going through this process is having a message. As Mark noted, a suggestive name conveys some kind of quality about your service. Is it fast? Is it trustworthy? Is it green? What message do you want to tell your consumers, your customers, your clients about your product? What is the most important thing that's going to differentiate you from the competition or give you a leg up, or really, in a word, suggest what it is that's important about your product. So thinking about what it is you're trying to communicate as you're brainstorming and coming up with names, the message you want to communicate is also a key idea. And finally, it's think big. It's easy to think small, think local, think in the present, but if we had named our firm Eric Pelton Trademark Law, we'd either have to change our name or be limited to trademark law forever. It wouldn't really cover if we do social media law or insurance law or some other field of law that we could get involved in someday. Same thing if you're a car wash and you call yourself Falls Church, the town we're in, Falls Church Car Wash. Well, if you expand, you're going to have to change your name, and if you or use a different name, and then you're going to lose the goodwill, the customer knowledge that's been built up in the name to date at that point. So think big. You always want to think about opportunities for expansion in terms of your products or services and in terms of your geography. Don't limit yourself if it's at all possible. That pretty much wraps up the section on practical ideas. At the end, I hope we're going to be able to take some questions. So if you have other questions about ideas for that, we'll be glad to answer them. Mark's going to carry on now.
Yeah, the third section are just the practical considerations that go along with all of this. One, the internet is obviously a very big issue for picking your names. You want to pick a name that has a domain name available. Whether or not an easy domain name is available might influence something about your mark. It might change the spelling. It might alter your strategy a lot. So that is one thing worth checking on. Another thing is your mark something that will find you easily if someone searches for it in a search engine? Is it just one common word? Will it bring up a lot of other things that aren't related to you? If someone puts your mark into a search engine, that might be something else to consider. Another issue is checking to see whether or not the marks you're considering are available as usernames for popular services like Facebook and Twitter. People are engaging with all sorts of services that they use today through a lot of different media sources, and you want to make it easy for them to find you through those things as well as elsewhere on the internet and just when they see your goods in the store. So these are all important considerations. One question we get a lot is, does your corporate name or your LLC name that you've filed with the state have anything to do with your trademark, or how does that affect it? It doesn't matter at all. The trademark is the name you put out there in connection with your goods and services. It's what people will know you by when they're buying what you're selling. The legal name of the entity that carries on those operations and owns the trademark, it doesn't have to be in front of consumers at all. There are many, many corporations out there with famous brand names that are owned by companies that you couldn't identify if you tried. And there's no use being concerned about, well, we've registered our company, or our company is legally called this or that. Don't let that restrain you if you can find a better name to identify yourself for the future. So as you consider all of these practical considerations and go through the brainstorming process, and you've narrowed it down to a few candidates, it's important to search. Get on the internet, go to the USPTO website, see if other people are already using the term for something similar. See if they're using different variations. And as Eric said, it's also important to file early. Here, we have to recommend certainly that it's not absolutely necessary that you get legal assistance for this, but we highly recommend it. The trademark application process can be complicated. There are a lot of ways that it can go wrong. And also the search to find whether other people are using marks that would cause a problem already is something that a trademark attorney can definitely help out with. Trademark attorneys generally have the capability of providing very comprehensive search resources that might not be available to you otherwise. They can provide you with an opinion about whether pre-existing trademarks out there in the world would cause a problem for you one way or another. And they can also make sure that your trademark filing is done properly. whether or not you can file an intent to use application or not, for example, is one issue, or whether or not you need to file a different kind of application. These are initial concerns that we see a lot of people who do it on their own make critical errors on. In addition to those things, there's also a lot of benefit to just having the help of someone who deals with the field a lot. One thing that we've been seeing lately are a lot of big companies that are trying to demonstrate a broad scope of protection for their trademarks. We've been calling them bullies, but it's kind of a new term. But there are marks that a traditional trademark search and legal opinion would say, well, if you're registering this term for one set of goods and services, there's someone else using that same term for something that's very, very different. That won't cause a conflict. But a trademark attorney might know that other company is very aggressive about enforcement and very aggressive about exerting their rights, even beyond, the legitimate scope of their rights. And so you might get a heads up in advance before you start investing in a mark that it's going to take a lot of time and a lot of effort to get through their challenges to your application. Even though you're probably going to win, it might not be worth the time and the money. And so these are kind of the things that a trademark attorney would bring to the table that an individual doing it themselves really wouldn't have knowledge about. And so, those are the practical considerations. You want to sum up, Eric?
Yeah, great. I mentioned our iPhone app, which is mainly for attorneys to use, and we call it App Attorney. And so I think it illustrates a good example of something that is creative, is suggestive in that it's an application, and it's in the field of law and attorneys. And we certainly brainstormed and went through all of the steps that I noted before, including filing to protect it and register it in advance of actually using it. So that's just one small case study of the type of name and an example of how we've been through the situation in addition to advising clients about those types of situations.
And as a coined term, there aren't other people who use it. If someone puts App Attorney into a search engine, it comes to us. The domain name was available, and what was the last thing there?
Well, in addition to the domain name, for example, the Facebook name and the Twitter handle and all those things are easily available as well.
Yeah.
We're going to hopefully take some questions. Before we do that, I want to just note that this call is being recorded for posting online. So if you have any particular specifics you want to ask about, you can either email us after the call or simply change the name in your hypothetical on the line. And I also want to remind everybody that nothing we've said here is formal legal advice. And if you have any questions about anything specific as it relates to your business or your trademarks, you should certainly consult an attorney. Let's see if we have any questions out there.